Hi, everyone. Harry here to talk about Trump's motion to dismiss the entire case based on the Supreme Court's opinion at the end of the term in the Fisher case. All right, let's just quickly review what that case was about. It's a January 6th marauder who is convicted on different counts of breaking and entering and doing stuff. However, 1512C2, an obstruction statute, one of the charges against him, and they just let him appeal it without the conviction just to serve up to higher courts. And the Supreme Court took the case and said you can't apply it against Fisher. And that was because the Supreme Court said it's a statute, an obstruction statute, and there was a very sort of picayune focus on a comma and the word otherwise and what that means. And Justice Barrett departed from the rest of the conservative majority. But the holding of the majority was that you have to be trying to impair the integrity of evidence. So Fisher's a guy who just all of a sudden, woohoo, jumps into the pool. Everyone's marauding, how fun. But they can't show. There are some people who are really focused on messing with the certification proceeding itself and really impairing the actual certification. And he's not one of them. He's just a freestanding marauder. So they reverse that. Now, Donald Trump. He is charged with obstruction, both conspiracy and a substantive count in the 4-count indictment in the January 6th case. And that had to do with trying to muck up the works of the January 6th proceeding, the certification, get Pence to break the law, substitute the phony elector certificates also. So Trump, as you can see, and we've been envisioning this for a while, even really since the oral argument when Justice Jackson raised a really interesting line of thinking. You could say, well, same thing with Trump. He didn't, shred papers, so you can't get him for that. But what the Supreme Court said was impair the integrity of evidence. And he is trying to impair the integrity of what evidence? The bona fide certificates that say Joe Biden won from the individual states. He's trying to impair it as much as if he were shredding them, right? So the question is, does his conviction stand? He'll have an argument, and the special counsel will have an argument. That was the state of play already. And then as part of the whole flurry that we've covered with the redaction and immunity back and forth, Judge Chutkan did say, bring your other motions too. Anything you have to motion to dismiss on statutory grounds, bring it. So unsurprisingly, Trump brought it. But unsurprisingly also for Trump, his motion under the Fisher case is wildly overreaching. He tries to make way, way more of Fisher than the opinion bears because he wants to use it to dismiss the entire indictment, including other charges. And first, by the way, he starts, this is so Trumpian, with an argument that it has to be dismissed because in some way that just doesn't really make any sense at all based on Fisher. He is not responsible for the events at January 6th or the attempts to impair the integrity. Why not? Nancy Pelosi is, of course, as everyone knows, and because she didn't provide the security, and she even said so. So for that reason, under Fisher, it's, causation would be a question under many statutes, but under Fisher, that's his lead argument you must dismiss. And then he really says, instead of hewing closely to Fisher and saying, I'm properly read. They're not showing any piece of paper that I shredded or tried to hide or whatever. But he tries to make the most general argument about Fisher. Under Fisher, says Trump, the office may not use the statute as a catch-all provision to criminalize otherwise lawful activity selectively mischaracterized as obstruction by those with opposing political views. That's not what Fisher says. It's not this general kind of principle of some residual because you don't like someone's political views. It's very particular about impairing the integrity of evidence. But Trump tries to say you've got to have proof of impairment coupled with corrupt intent. That's true, but the corrupt intent part is nothing that the Supreme Court spoke to. It's really evidence impairment. That's what Fisher is about. So his attempts to use it as some get out of jail free card for anything that has a whiff of politics is really just beyond the pale. Now, he's got to be expecting that he's not going to win this in front of Chutkan. And so the question's going to be, how's this going to play higher up and the Court of Appeals and the Supreme Court? Although Chutkan's a very solid law-abiding judge from what we can tell. If he really made the narrow argument, I think she'd give him his day in court fully. But he's going to want to use Fisher for all it's worth as another attempt to just make the indictment go away. For that, he's going to need another very expansive, friendly Supreme Court to take it beyond its moorings. But that's basically the way he has now argued it in front of Chutkan. I think she will narrow the argument to the proper point of, is this evidence impairment? That's what this is about. But he will have in his papers and then bring up both his general diatribes that are covered by the press now and have some way of asserting that he's just being singled out for politics. And then also he'll have in his papers the widest possible construction of Fisher, really wider than possible, in case, though, he needs to be able to say on appeal, make some similarly wild-eyed argument, and normally you can't do a whole new argument on appeal, so he'll be able to say, no, look, at just page 2, I said Fisher means the whole thing has to go away, etc. So there you have it with Trump as instructed by the court, bringing a motion to dismiss based on statutory grounds, the Fisher case, but throwing a huge net over the whole prosecution and more over January 6th, over Nancy Pelosi, etc. It's quite Trumpian. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.